Sunday.
My lord, my lady, this morning you were told that junior counsel for the second intervener, Millie Polymac, was not in the room, and that was right. But she has this afternoon graced us with her presence. So junior counsel for the second intervener is now in the court.
Well, she can hear me say that we're grateful for the assistance that her submissions have given us.
Thank you very much, my lord. I am going to make submissions in relation to the first ground of appeal and in response to shelter. I expect to take 65 minutes to do that. My learned junior, Michael Mullin, is then going to make submissions in relation to the second ground of appeal, and he expects to take about 20 minutes, and then I will deal with the third ground of appeal in our last 20 minutes. There are three things that I wanted to respond to that arose this morning. The first, my Lady Rose, is in response to your question about which set of the provisions apply. It is right that the 2012 to 2018 set of provisions apply, but as I think my learned friend Mr. Bates, KC, indicated, there's really there's no practical or material difference between the current set of provisions and the 2012 to 2018 set of provisions. My Lord Reid, in response to your question about somebody never having been eligible because they were not ever, never having been owed the Section 193 duty because they were never eligible for assistance, in fact, what Section 193 subsection 1 says, and it's at page 465, my lord, my lady.
Yes.
This section applies where the local housing authority are satisfied that an applicant is homeless, eligible for assistance and has a priority need, and are not satisfied that he became homeless intentionally.
Yep.
So it isn't, in the first instance, for the duty to arise, it isn't about the fact, it's about the local housing authority's view of the fact. Mm-hmm. So you can see that the duty may have arisen even though they were ineligible for assistance because the local housing authority was satisfied that they were, but you're right that the duty ceases if they cease to be ineligible.
Well, I'm glad to know I got one thing right.
And then thirdly, I wanted to deal with my learned friend Liz Davis's concession re section 1936A in response to questions by my Lord Sales in relation to a change in regulations concerning immigration status and eligibility. What happens when the Home Office tell a local authority that this person will cease to be eligible for assistance, and the local authority in advance tell the person that that means that the duty will cease to them on a future date. And as I understood it, Miss Davis's concession was that that notification and decision would be reviewable under section 202(1)(b. And as I understand it, that must be an end to this appeal, because if a...
Sorry, I thought it was the concession...
202(1)(a), I apologise.
1A, yes.
But the same must apply in relation to section 202(1)(b. And in my submission, that must be an end of this appeal. Unless it's A's position that the different routes to cessation have different post-event notification and decision requirements. So not only are you being expected to read in certain extra clauses in respect of some of the routes to cessation, in relation to others you aren't. And with respect to my learned friends, that's just chaotic and couldn't be based on proper statutory interpretation.
Well, I think it might be said on the other side, looking at section 202(1)(b, if one focuses on what duty is owed to him, the submission was made, that knocks out prospective decisions.
I'll come to that.
I'll come to that. Okay.
Yes. In fact, that's my very next point. Throughout her submissions, my learned friend Miss Davis, KC, and throughout his submissions, my learned friend Mr. Bates, KC, continue to use the phrase prospective decision. There is no judicial authority calling these decisions a prospective decision. What they are referred to is a decision that has prospective effect. You might say that's semantic, but in my submission it isn't, and it matters. The only judicial statements in which the mental element is put before the outcome is the decision of the Deputy High Court judge, as he then was, in the first instance decision in this case. So he doesn't use the word or the phrase prospective decision, he uses the phrase prospective intention. In Ravi Chandran, at page 1440, paragraph 32.
Sorry, what was the page reference?
1440, my lord.
Thank you.
What is said there is a decision to prospectively apologise. Paragraph 32, right at the bottom of the page. We do not accept that criticism if, following the making of the offer by Lewisham, or at any event once there had been a refusal of the offer, there had been a review at the same time both the suitability and the reasonable to accept requirements, as well as the decision prospectively to discharge by the making of the offer. In my submission, there's a large difference between a prospective decision and a decision prospectively.
Yes. On Ravichandran, I think the similar reasoning is reflected in paragraph 35(6), isn't it?
It is, yes. And that's picked up by Lord Justice Newey in the Court of Appeal in this case. He doesn't use the phrase prospective decision. And he says, in effect, that there was no authority, or Ravichandran was not authority for the Deputy High Court judge's finding of a prospective intention or prospective decision. So my learned friends are wrong to say that there is a prospective decision. There is a decision that has prospective or future effect. As you're aware, the Housing Act Section 193 has been amended on 11 occasions, 10 occasions, another one's in the pipeline with the abolition of assured short-hold tenancies.
I'm sorry to interrupt you. It's just while we have this case in front of us, I see the second half of paragraph 31 is perhaps relevant. Because it's talking about the case before the court being one where Lewisham came to a decision in January 2009 about whether or not its duty had ceased. The effect of Warsami is that its decision taken then, even if only confirmatory of a prior automatic discharge, was reviewable under 2021B.
Yes.
Yeah. That bears on some of the points we were discussing this morning.
My lord, it does. When Warsame was decided was at the time at which there had to be a post-event notification in relation to what was then a Part 6 offer. Yeah. And the facts in Warsami support what happened was in Warsami there was a decision that the accommodation was reasonable for the applicant. Sorry, a decision that the accommodation was suitable. They went to visit the accommodation. Events happened, and they were interviewed after their visit to the property, and the local authority took into account the content of that interview. So additional facts were raised after the offer had been made, which were relevant to what the local authority then had to decide as to whether or not its duty had ceased. Because at that time, the accommodation not only had to be suitable, it also had to be reasonable for the applicants to accept. So you can see why in that case, there was a post-event notification, which encompassed or included a decision. If we look now at the current 9...
And I'm so sorry, I think you told us that there was some difference in the regime that was applicable at the time of Waltham,
Yes.
which was...
So at the time of Waltham, there was no right of a private rented sector offer bringing the duty to an end.
Yep.
So it could only be ended by a Part 6 offer. The duty only exists, and the other methods of cessation. It's probably easiest if you look at section...
But isn't the key... Isn't the point that at the time of Wasami, the suitability test was only applied after...
No.
Or was that an earlier iteration?
That's an earlier iteration. I can take you to Waltham.
Well, no, then just answer, my lord.
Well, that's fine. If you turn back, my lady, to page 437 in the bundle, that is the version of section 193 that was in issue in Waltham. And Waltham is at 1482. In Waltham, the issue was that the local authority had notified the applicant that its duty had ceased. His Honour Judge Oppenheimer, who used to sit at Brentford, had decided that that didn't come within the right of review because it wasn't a decision as to what duty is owed, and Lord Justice Chadwick held that a decision that a duty is no longer owed came within section 2021B. And so there was a right of review and therefore a right of section 204 appeal. Waltham is really a decision from gentler times when people were given an opportunity to have a look at the property before they had to accept it. And in Waltham, it's clear that they raised issues about the accommodation that they had been offered, which the local authority took into account in its notification that it regarded the duty as having ceased.
And was at that time there a statutory obligation to give notice that the duty is...
So that's at page 437, my lord?
Yes.
Right at the bottom of the page. So subsection 7, that's the Part 6 refusal cessation. The local housing authority shall also cease to be subject to the duty under this section if A, the applicant, having been informed of the possible consequences of refusal, refuses an offer of accommodation under Part 6, and the authority are satisfied that the accommodation was suitable for him and that it was reasonable for him to accept, and notify him accordingly within the 21 days of refusal. Now, it could be said, well, all you had to do was notify them. But what happened in Waltham was there was an interview at which Mr. and Mrs. Waltham raised reasons why it was not reasonable for them to accept the accommodation. And that formed part of the notification decision. If we go back to the current iteration, or the iteration of section 193 that applies to Miss Bano, it's at page 465. There are 9 routes to the cessation of the section 193 duty. Before I go through them, I just wanted to say some general things about the ideal outcomes or the utilitarian outcome of section 193 within the context of the 1996 Act. So the 1996 Act makes separate provision for allocation of social housing, to which the local authority has rights of nomination. That's the first time that happened. Prior to the 1996 Act, there was no statutory provisions for how social housing is allocated.
And social housing is housing which they own or is owned by a housing association?
It's housing which is owned by the local authority or owned by a housing association, yes. And it will normally be at a below market rent, or anyway, the definition of social housing in the Housing and Regeneration Act 2008 is if it's provided on rental terms, it's provided at below market rent. Under Section 193, or the purpose of Section 193 is that a homeless person in the category defined in Section 193(1), so that's not all homeless people, but that's home. I mean, this is an awful phrase, but one could say the deserving homeless people. So they're eligible for assistance, they haven't made themselves homeless, and they have a priority need. And the purpose of the section is to meet their immediate incidents of homelessness by providing them with somewhere more permanent, but not with providing them with something indefinite or totally permanent. Now, it's absolutely right that it may be that where the Section 193 duty is owed, that is an avenue to being offered a social housing tenancy, so an offer under Part 6. And we'll come to the fact that the duty ends if you are made an offer under Part 6. But it isn't the only way. If we take this case, and under Part 6, a lot of local housing authorities now operate what's called a choice-based letting scheme. And what that does is it gives you points as a result of your characteristics, and then you have a right to bid on the choice-based letting scheme for social housing that becomes available. If we take this case, we can see that Miss Bano was placed on the council's choice-based letting scheme at page 223, which is what is called the Section 184 decision letter, telling her that she was owed the Section 193 duty. So on the second page of that letter, in bold, about halfway down, it says, please note that you will need the following details to bid for properties on the choice-based letting scheme. However, until and unless she was successful on a bid, or was otherwise offered a Part 6 accommodation, or the duty to her ceased in some other way under the Act, she was continued to be owed the Section 193 duty. My learned friend Mr. Bates is correct in saying that the way this works is through a series of statements.
So the bidding for properties, that's to get a Part 6?
That could be a Part 6 offer, but local authorities also usually reserve to themselves the power to make Part 6 offers directly. Anyway.
Yes, okay.
And which section deals with priority needs?
Section 189.
That's okay, we don't need to go to it.
It's on page 462, my lord. The categories are a pregnant woman or people with whom dependent children reside, a person who is vulnerable as a result of old age, mental illness or handicap, and a person who is homeless as a result of a emergency, flood, fire or other disaster. So Mrs. Bano had, I suspect, had priority need because she had dependent children. She may have had other vulnerabilities. We don't need to investigate those. But in effect, what we're dealing with under Section 193(1) is the people who are most in need of immediate accommodation to meet their current homelessness. My own friend Mr. Bates was right in that what happens in practice is that there's a series of staged sets of accommodations. So somebody presents as homeless and they're offered something immediate to deal with their immediate homelessness. That's before the decision has been made. And that's under something called the relief duty, which was introduced by the Homelessness Prevention Act, or alternatively under Section 188, subsection 1, which says that where the authority have, that's at page 462, my lords, where the local authority have reason to believe an applicant may be homeless, eligible for assistance and have a priority need, they shall secure that accommodation is available for his occupation pending a decision. So that, of course, holds the ring until we've got to our are you owed the Section 193 duty or not. Again, using this case as an example, what often happens is that the accommodation that was provided as interim accommodation is used to perform the Section 193 duty in the first instance. So again, looking at page 222, the penultimate paragraph on the first page, Waltham Forest says, the accommodation you are currently occupying will remain available to you as the first stage in discharging our duty to provide you with suitable accommodation. All accommodation that is provided under Part 7 must be suitable. And Mrs. Bano was told in this letter that she has a right to review the suitability of this accommodation.
You mean the temporary accommodation?
Yes. And that, my lady, is at the top of the third paragraph down on page 223. You also have a right to request a review of the suitability of accommodation you are currently occupy.
And as a result of the council accepting full homelessness duty, that is the Section 193 duty?
My lord, yes.
Yeah.
As a result of the insertion of the provisions under the Homelessness Prevention Act, local authorities now also have a duty to try and relieve somebody's homelessness before, in effect, to try and prevent their homelessness. And they have a duty to prepare something called a personal housing plan. So there's a lot of dialogue between the local housing authority and the applicant about what is suitable. And we'll show you in due course, I'll show you when the Section 193 offer is made, in this case, how intimately Waltham Forest must have been presumed to know about Miss Bano's suitability housing needs. Coming back then to the, my lords, to the different ways in which the Section 193 duty can be caused to cease. So there are three solutions, or three resolutions, which achieve the ideal solution of more permanent accommodation for the applicant. They are 1936A, and that's if the applicant accepts, sorry, not 1936A, I apologize, 1936C, accepts an offer of Part 6 accommodation. Now, as I understand it, both on Shelter's submissions and on my learned friends for the appellant's submissions, there must also be a notification letter telling them that the duty ceased if they've accepted a Part 6 offer. Well, the ideal solution has been achieved, but you've got to tell them that the ideal solution has been achieved. Section 1936CC, or CC, and that is at the bottom of page 465, where the applicant accepts an offer of an assured tenancy other than an assured short-hold tenancy from a private landlord. 1936CC. Not 10cc, but 6cc. So that again, that somebody has a tenancy that can't be determined without a ground. Again, the ideal solution of a slightly more permanent accommodation has been achieved. And then the last one is section 1937AA little a. So that accepts the private rented sector offer.
And sorry, just on the CC one, presumably you would make the same comment about the appellants and shelter submission. They say you have to tell them.
And it's very unlikely that this is going to happen through the offices of the local authority. It's much more likely that the person achieves this for themselves. So you have to tell them, notwithstanding that they found their own assured tenancy agreement, that your duty to them has ceased.
Well, it's not so preposterous if it. I mean, who knows
No,
whether they offer it, whether then they move
Yeah.
in there, it's going to be fine, or it might be appalling and they have to move out in 4 days. So.
Well, if they accept the offer of the fully assured tenancy agreement that isn't an AST, so it can't be determined by a Section 21 notice, the duty ceases whether it's appalling or not.
Well, that's your case, yes.
Yes. Well, that's what the Act says.
Anyway, you were going on to
The next two I want to consider is where the applicant thwarts by refusal.
I'm so sorry, it's my fault. I didn't note down your third example, which is after the CC example.
Sorry, 1937 AA, capital A's, A. So that accepts a private rented sector offer.
Oh, right, our provision.
Yep.
Okay,
Well, we're B because she refused.
okay, fine.
Insofar as Section 7AA is concerned, there's all the protection that we have about having to be notified that the local authority consider that the local authority has to be satisfied before it makes the offer that the accommodation is suitable. And that's not an unonerous set of requirements insofar as private rented sector offers are concerned. Those requirements are set out in the 1996 suitability order, which is at page 1520, which effectively says that the accommodation has to be affordable by the applicant over the long term. You need to look at Article 2 of the 1996 order on page 1521. And then the 2012 suitability order, which is starts on page 1526, and you need to look at Articles 2 and 3. Article 2 deals with the location of the accommodation offered.
And do both of these apply?
These apply.
Yeah.
So it's not just a question of a local authority sucking its thumb and saying, we think this is suitable for you. They have to be satisfied of the matters in Article 2 of the 2012 order and Article 3 of the 2012 order. Article 2 deals with location. And Article 3 deals with the personal characteristics of the landlord and the physical characteristics of the property.
And does this now incorporate something that used to be dealt with under the whether it was reasonable for them to accept it in the earlier iteration of the legislation?
So the 2012 order was introduced when private rented sector offers became a common way of causing the duty to cease, and they were a way of protecting the applicant who was made a private rented sector offer in relation to the location and the quality of the accommodation. So I don't think, my lady, that there was a direct correlation between the two. So going back to the ideal solution, Section 1937 7. The local authority ceased to be subject to the duty under this section if the applicant, having been informed of the possible consequences of refusal or acceptance and of his right to request a review of the suitability of the accommodation, refuses a final offer of accommodation under Part 6. And that, my lady, my lords, is on page 466. So there was no upfront prior obligation to notify if you accepted a Part 6 offer. But in order for a Part 6 offer to bite as a cessation event, if it is refused, the applicant has to have been informed of the possible consequences of refusal and of their right to review the suitability of the accommodation. So that is fair.
That's 7AB.
That's 1937 simpliciter. No more, nothing else on it. Top of page 466. And that relates to a Part 6 offer. So that's this offer of a social housing tenancy, my lady. Section 7AA(b), little b, for just a couple of paragraphs down the page. The local authority shall also cease to be subject to the duty under this section if the applicant, having been informed in writing of the matters mentioned in section 7AB, B, refuses such an offer. So all of the notification is front-loaded.
And in this case, it wasn't.
In this case, there was section 1. There's a case called Haringey and Norton, which I had the pleasure of doing in the Court of Appeal, in which, although Haringey had alluded to the impact of section 195 in their offer letter, 195A, they hadn't included all of the detail about the impact of section 195A. So that there's right that in this offer letter there was an error, but it was and it would have, for these purposes, invalidated the offer. If the point had been taken, the offer could not have been relied upon.
It's a precondition. If you don't comply with it, the offer isn't a valid offer.
Absolutely. And that can be determined on a section 202 review. So what are the matters set out in section 7AB? They are the possible consequences of refusal or acceptance of the offer, that the applicant has the right to request a review of the suitability of the accommodation, and then the section 195A matters.
And why is the B limited to review of the suitability when, I mean, on the arguments we've been hearing, there is also a power of general review under section 202(1)(b)?
So in this, what happens, in fact, and you'll see it, is that the letter is also must also tell the person about the consequences of acceptance or refusal. So they are being notified of the general effect of the offer. They're not told, it's right, about their right to request a review of the cessation of the duty.
Well, the consequence of acceptance or refusal is limited if you have a right to review it. And if you can review it, then there is no consequence.
Yes.
So, well, isn't it procedurally unfair not to inform a person that they have a right to review a decision as to whether the main housing duty comes to an end?
In my submission, no, it isn't.
How do they exercise this right if they're not informed about it?
That there are other rights that people have and they lose as a result of decisions that are made where they are told of the effect of the decision but not necessarily of the avenue for challenge.
So you don't read, or you've not so far read, as included in 7AB(a), that a possible consequence of the refusal is not only that the main housing duty will come to an end, but that they would have a right to request a review of that.
That isn't being argued.
Well, but all the same, what's the answer?
My submission in relation to that is Parliament has decided what the letter must notify people about, and as my learned friend Miss Davis has conceded, I think, that the battleground is usually about suitability. So the other matters she raises are, have they accepted or not accepted? Well, with respect to her, there's one case about that that's troubled the appellate courts, and it was clear that the accommodation was refused because the tenant didn't, or the applicant, proposed tenant, prospective tenant, hadn't signed the tenancy agreement. So what happens is in relation to private rented sector offers under section 7AA is that the notifications are front-loaded. There are then...
Just taking you back to 7AB.
Yes.
You have to inform the applicant of the possible consequence of refusal or acceptance.
Yes.
And a possible consequence is that it has absolutely no consequence at all because you can review it.
So in my submission, if you read 7AB in the context of 7AA, the consequence referred to is that the duty shall cease in the event of acceptance or refusal. So what then are the other ways in which the section 193 duty can be brought to an end?
And just before we leave the point we're on, looking at section 1937, that same difference between you've got to notify of right to request review of suitability,
yes,
but not
of.
All right.
The other ways in which the duty might cease are, there are three of them in effect where the applicant thwarts the performance of the duty until before it has ceased, if I can put it like that, before it has ceased by the ideal solution. So under section 1935, on page 465, the duty ceases if the applicant, having been informed by the authority of the possible consequences of acceptance, of refusal or acceptance, and my Lord Sales, we get the same again, and of the right to request review of the suitability of the accommodation, refuses an offer of accommodation which the authority are satisfied is suitable for the applicant. That offer of accommodation is not an offer of accommodation under Part 6 or a private rented sector offer, and the authority notify the applicant that they regard themselves as ceasing to be subject to the duty under this section. So you'll see in that subsection 1935 expressly provides for a post-event notification. Insofar as the other two that are the applicant thwarting the performance of the duty as opposed to thwarting an event that will cause its cessation, section 1936B becomes homeless intentionally from the accommodation made available for his occupation. It is right that the local authority may have to make a decision about whether or not that person is homeless intentionally. But where they are homeless intentionally from is accommodation that's being provided to them to perform the duty. The local authority may have no idea where they are.
So it's made available under these powers, then?
Yes. In section 184 and in sections 189A and B, there are deeming provisions for somebody having been given notice. So at page 433, which is section 184,
What page, sorry?
433, my lady. (184) subsection 6, notice required to be given to a person under this section shall be given in writing and, if not received by him, shall be treated as having been given to him if it is made available at the authority's office for a reasonable period for collection by him or on his behalf. Now, what we have in section 1936A, sorry, I apologise, B, 1936B, is somebody's homeless from the accommodation that they're being provided with to perform the section 193 duty before it ceases. And so the local authority doesn't know where they are, may not know where they are, and there's no deeming provision for service of a notice. So in those circumstances, the section 193 duty, if Shelter and my learned friend are right, the section 193 duty continues until that person comes back or is served a notice. And then section 1936D, which is over the page at 466, otherwise voluntarily ceases to occupy as his only or principal home the accommodation made available for his occupation. Again, they've ceased to occupy the accommodation that is being made available for them to perform the duty. And how does the local authority know where they are for the purposes of serving a notice? There is no deeming service provision. The last one is the one that we discussed or was raised quite a lot this morning, and that's 1936A, ceases to be eligible for assistance. If somebody comes within section 1936A, the local authority has already been satisfied that they are somebody to whom the duty is owed. So the duty must be being performed. They must be in accommodation that the local authority has secured for them.
To fit within A?
1936A. In any order, but yeah. So, what happens? Well, the local authority is told that this person, by the Home Office, that this person is no longer eligible for assistance. The local authority knows where they are. The local authority will write to them to tell them the accommodation that you are being provided in the interim, in performance of our duty, is no longer going to be available for you because you have ceased to be eligible for assistance. So as DeWege identified at 33, and that's at page 779, and my learned friend Mr. Bates took you to it. I was surprised because I wasn't sure how it supports his case.
Which paragraph do you want?
33, page 779, over the page to 780. Top of the page, section 1936A may theoretically not even require a decision. That's right. Although no doubt the local housing authority in practice needs to communicate its view. Well, it will communicate its view because the accommodation that is being provided in performance of the section 193 duty is going to be withdrawn. So in every single instance, although one might say these events or routes to causing of the cessation of the duty...
But in that paragraph, it goes on to say 2021A seems to contemplate a decision. So that's what one of the things we were debating.
Yes, it
whether
does.
Actually, because of the need to review, you have to read back into section 193.
6A.
Well, generally, an obligation to notify or to take a decision and notify. So how do you say it works if it... if
In
there's no decision required?
In practice, if the accommodation is the accommodation that is being provided by the local authority in performance of the section 193 duty, and the local authority is told by the Home Office that this person has ceased to be eligible for assistance, the local authority, if it's going to cease the provision of the accommodation, will have to inform the applicant that the accommodation will no longer be provided. And the decision is we're no longer
Well, the
going
question is how they do that. Do they do that in a way that makes it clear that it's a decision which is reviewable under 2021A?
Well, in my submission, until and unless they tell the person that there's a decision as to their eligibility for assistance, the right to request a review of the decision arises on any decision of a local housing authority as to his eligibility for assistance. And in my submission, the local authority writing and saying we're no longer providing you with this accommodation because it's come to our attention that you are no longer eligible for assistance comes within section 2021A in the way that a duty that a decision that the duty is no longer owed comes within section 2021B under Warsame.
So if you're notified that the local authority are going to do something to you, and the basis for that is because you're no longer eligible for assistance, you say that counts as a decision that you are no longer eligible for assistance, and the 21 days runs from
Yes.
that letter.
Yes. If we look at the decision letter in this, the offer letter in this case, you can see the operation of the provisions insofar as they relate to private rented sector offers, but in my submission also as they would relate to Part 6 offers in action. So, on page 2...
If I could, before you go away from section 202,
Yes.
there is in 1A an ability to request a review of any decision of a local housing authority as to his eligibility for assistance. If he's not eligible for assistance, then by operation of law, the housing duty comes to an end.
Absolutely.
That's my understanding. So therefore, there would not need to be any decision within B of a local housing authority as to what duty of any is owed, because there is no requirement for any such decision.
My Lord, yes.
Okay. Then how about 193(6)(b) becomes homeless intentionally from accommodation?
Yes.
Because there is there's no right to review that decision.
Well, in my submission, that would involve a decision. In my submission, that would involve a decision
As to
of the
what?
local authority as to intentional homelessness. But it's a
Yes,
decision that the duty has ceased.
Yes, well, then it falls within section 202(1)(b).
It does, my Lord.
Yes. And
In relation to why is there no why is the fact that there is no notification requirement in relation to an intentional homelessness decision not unfair? It's not unfair because how does the local authority give notification to somebody who has ceased to occupy the accommodation that they have been being provided with? Where are they? Without a deeming provision for service of notification.
Well, they may be there, but you may now decide that they actually were intentionally homeless. They may still be in the same apartment, in the same house.
Sorry, that's not what section 193 6. Which one is it? 6C. Sorry, let me find it. What 1936B says is becomes homeless intentionally from the accommodation made available for his occupation under this section. I think we could read in there, probably.
Right, because if they're just homeless intentionally, then that fits within eligible for assistance.
Yeah, they wouldn't have been owed the section 193 duty in the first place.
Could I just ask you a question arising out of what you were saying about Warsame and how section 202(1)(b) operates in the same way as section 202(1)(a)? So I think you said that if someone ceases to be eligible, the local housing authority writes to say, you're no longer eligible, give us back the property. in effect, and that would be a decision as to his eligibility for assistance within section 2021A.
And the notification required to trigger the right of review.
Yeah, that they know
Yes.
that if they want to do something about that, they know something's happening which isn't good for them,
Yes.
and they can take steps. My question is, take our sort of case where it said that the duty ceases because of non-acceptance of the offer. I think your case is that the making of the offer is itself a decision as to what duty is owed.
So
But my question then is, if that's a decision as to that, it may well be, as in the eligibility for assistance case, that will be followed if the person doesn't leave the property that they're in, that the local housing authority will have to do what they would do in an eligibility case and say, please now vacate the property.
Yes.
Would that second event count as a relevant decision under section 202(1)(b)?
it would be a notification of the decision. If there had been an... So this is really a... The Court of Appeal found that the subsequent correspondence between Miss Bano and Waltham Forest, the respondent, were or included decisions that were reviewable. That is largely a result, in my submission, of the decision in Warsame and Ravi Chandran.
Ravi Chandra only.
Or Ravi Chandran only.
So in answer to my question, I think you're telling me that the Court of Appeal said, yes, the second decision is also a decision within section 202(1)(b) as to which a right of review would arise?
Yes.
And is that your case?
It's more nuanced than that.
All right. So what's your position?
So the position really is this. A notification may not be a decision.
Notification of what?
A notification that a decision was made previously which you were informed about. The problem with a further notification is it gives rise to a further right of section 202 review, is that solicitors acting or people acting for themselves might write to the local authority and say, can you confirm that the section 193 duty to me has ceased? And that gives rise to a review under section 202(1)(b), although in fact the decision occurred some time ago.
Right.
In this case, what was happening was there was a resistance to a judicial review claim. The resistance was put on the basis that you had an alternative remedy, which was review, and you're well out of time. So if you go to...
And when you say out of time, you mean for the review under section 202?
Or for judicial review.
Right. So both. Both.
Both.
Sorry, you were going to take us
Yes,
through
no,
a-
if you go to page 239 in the bundle, that's the letter dated the 7th of October 2020. And that was the response of London Borough of Waltham Forest to a request for review at page 236. Whether the letter dated the 17th of October 2020 gave rise to a right of review or to a right of judicial review, it was much more than 21 days or 3 months before the launch of the judicial review in this case.
So this letter did the trick so far as you were concerned in defeating the judicial review.
Absolutely.
But you're rather dancing around whether you accept that actually this was a reviewable decision or not. It wasn't necessary for the court to decide that.
It isn't necessary for the court to decide that. And it's probably, I should confront this head on. If we go to Ravi Chandran.
Well, before doing so, I have great difficulty in understanding how, if the main housing duty comes to an end by operation of law, anyone can thereafter make a decision about it. You have to make a decision. You have to decide between two potential options, and if it has come to an end by operation of law, then there is no decision to be made. The law states what the outcome is.
So, my Lord, in relation to acceptance or refusal of either a Part 6 offer or a PRS offer, so to cause the duty to cease under any of those relevant subsections, in my submission, the decision has been made when the offer is made.
Sorry, and that brings the duty to an end.
And it brings the duty to an end.
Yeah.
That is the decision that is reviewable. And that deals with the Peabody point about when does my 21 days run from? The 21 days runs from the date of notification. And that's what the letter says. The offer letter in this case says your right of request for review runs from 21 days.
So what is someone like Mrs. Bano to do when they get this letter? The letter tells them you've got to accept this because it's only, the landlord's only making this property available for acceptance in the next 24 hours, or 2 days. She knows she's not going to be able to go up there and look at it. So what's she supposed to do? Just accept it without seeing it, and then the landlord then lets go what other person he's got in, and then she goes up to see it at some time more convenient for her or possible for her, and it's completely unsuitable. How should this have played out, if I could put it that way?
So people who are made these PRS offers are in an invidious position. I accept that. There is a real struggle between accommodation being suitable as affordable for people who are on benefits and it being suitable by reference to location. I had a look at the ONS website at one occasion, and the only places where there was significant accommodation at the housing benefit rate for the housing element of universal credit is Solihull. People who are in London, who are being offered PRSOs by local authorities in London, are going to be offered almost certainly out of London. Although you're familiar with the case of Nzolomezo, in which Baroness Hale gave some guidance as to holding some property back for people who cannot be moved away from their location. So it's absolutely right that people who are in this situation are in an invidious position. What the local authority does in its letters is says, we would recommend you accept it and challenge suitability if you are not satisfied with it. But the purpose of this legislation is not to provide people with long-term social housing. The purpose of this legislation is to meet an immediate homelessness need.
So if she had accepted it...
She could have challenged suitability.
Right, but does she have to... So then presumably she would have entered into a lease with the...
With a tenancy agreement, yeah.
With a tenancy agreement. So then, on this basis, the landlord is told, yes, you've got a tenant coming in, but that may not be true at all.
No, the tenancy agreement will be executed because that is a necessary consequence of acceptance. There are provisions allowing tenants under assured tenancies to give notice to quit, and there'll be a challenge to its suitability. And if it wasn't suitable, it didn't amount to a private rented sector.
What happens to all her belongings then? Does she have to move them all up to
Yes.
Derby and then move them all back again?
Yes. But I'm afraid, my lady, that the legislation cannot be interpreted on the basis that we currently have a housing crisis. The legislation has to be interpreted on the basis of the intention of the legislation.
I'm very keen that you do get to Ravichandran, but could I just say you didn't actually answer my question. You said, well, it's a problem if there's a further right of review because solicitors will keep on writing and then sort of triggering further rights of review. And I follow the problem, not quite sure what the answer is, but my specific question was, suppose a case like ours, the offer is made of the private sector tenancy. Whether you accept it or you don't, the housing duty comes to an end. You say decision to make such an offer is a decision which is reviewable. My specific question was, you said in relation to section 202(1)(a) that if there's a decision or recognition that someone is not eligible, at the point when you try and remove them from the property, that is itself a decision as to eligibility for assistance. And then my question was, in our sort of situation, yes, you've written the letter requiring the offer to be made and accepted or rejected. The housing duty has come to an end. You now have to remove the person, and you do precisely the same as you would do under section 202(1)(a). You get in touch with them and say, please get out.
So the difference is...
And why is that second one also not a decision?
So the difference in this case is that the person who ceases to be eligible for assistance is only told of the cessation of the duty to them by the letter saying we're stopping providing you with this accommodation.
Sorry, so you're saying that's the distinction between your answer under section 202(1)(a)?
Yes.
So in effect, that seems to come down to, well, you can only ever have one decision.
In relation to different aspects, you can have notifications, different notifications.
But only one notification per aspect.
Yes. Once you're given the notification, that's it. Right. And that brings us, helpfully, to Ravichandran. So in Ravichandran, the local authority had made a Part 6 offer. So it was a case under section 1937 because the Ravichandrans had refused it. There was lots of going backwards and forwards, and at that time, in the time that Ravichandran was decided, the Act also provided that the accommodation had to be reasonable for the applicant to accept. In the various reviews that the local authority carried out, it had not considered that question. The question it considered was the accommodation reasonable, not reasonable for the person to accept, or for Mr. and Mrs. Ravichandran. Andrew Arden, QC, representing the local authority, spotted that problem and argued that the discharge of duty came under section 1935. So he said, no, it's a section 1935 case. And at that time, section 1935 did not make provision that it only applied where there was where it was accommodation that was being offered in performance of the duty. What the Court of Appeal decided in Ravichandran was a section 1935 offer must say it's a section 1935 offer, a section 1937 offer must say it's a section 1937 offer. You can't, as a local authority, then turn round and say, although we said this was a section 1937 offer, we're now relying for our discharge of duty on section 1935. And that, my lords, my ladies, at paragraph 35, page 1441. And you'll see there the first 5 principles were relevant to the decision and were necessary for the decision. The subparagraphs 6, 7 and 8 over on page 1442 were not necessary. For the decision, but they do refer to a review taking place before accommodation has been refused at paragraph 35, subparagraph 6.
So at the end of that subparagraph, it says the applicant should be informed of
Yes.
the right to such a review.
There's nothing in the statute making that requirement.
So you say it's not in the statute, there's no such right.
Yep. And this part of the decision is obiter for the outcome of the case in Ravichandran.
And I think the guidance, the housing guidance, says something similar, doesn't it?
It does,
You say, well, it's not in the statute.
yes. And Parliament has been very careful about telling local authorities what they must and must not notify people of.
Well, they say it's practical assistance, which is how they head up this list.
Yes. But the principles of 35, 1, 2, 3, 4 and 5 were necessary for and necessary consequences of the outcome of the case, in which Lewisham was seeking to argue that an offer that it had made under section 1937 could result in a discharge of duty under section 1935. And that was because the local authority had not at that stage carried out a review of the question of whether or not it was reasonable for Mr. and Mrs. Ravichandran to accept the property, notwithstanding that Mr. and Mrs. Ravichandran had told the local authority that after they had viewed the property, or at the time of viewing the property, they'd been subject to racial abuse. And that was something that the local authority had not considered. And the Court of Appeal considered that that was relevant to whether or not the accommodation was reasonable for Mr. and Mrs. Ravichandran to accept. So you can see that in those circumstances, the local authority hadn't reviewed, or its review was unlawful, because it hadn't asked itself the right question and it hadn't taken account of factors that had been put to it by Mr. and Mrs. Ravichandran. I'm aware of the time. My learned friend, Mr. Mullen, wants to make submissions on ground 2. I haven't addressed Anu Jufreva, which I can do very quickly. Anu Jufreva is a decision in judicial incandescence, if I can put it like that. The Home Office were deliberately not notifying people of their asylum status. The explanation for that, or the rationale, not the upfront explanation, but possibly the reason behind the decision was that meant that they had no money to go to their reasons for refusal hearing in Croydon. That is a very far cry from this case, and in my submission, Mr. Bates's submissions on this point are dependent upon there being a further decision that has to be made. It's a very far cry from the offer letter in the current case, which
With the offer letter in the current case, so is there a mechanism, whether it's somewhere under 202, for a person in Mrs. Bano's position to say, I would like to go. I'm happy to move to Derby, but I cannot get there on Monday because I'll lose my job or my child's having an operation. And then they say, sorry, you're deemed to have refused. What is the mechanism, or does it exist, whereby she can challenge the reasonableness of them bringing the main housing duty to an end in a way which she says is completely unreasonable?
So my lady, the problems that are identified by the applicants as reasons why they are concerned have not troubled the courts.
Well, they're troubling me. So
I appreciate that,
yeah.
but it appears that they are being resolved by the sensible application of the current provisions by local authorities. If a local authority said, no, we're taking the view that you, even though you've gone to hospital, even though you have an operation on that day, we are taking the view that you have rejected the offer and you have, and therefore our duty to you has ceased. In my submission, that would be subject of judicial review.
So you say there's no mechanism within the Act?
No, but as my Lord Stevens pointed out, there is a discretion to extend time for Section 202 review.
No, I'm not talking about the Section 202 review. She may be able to bring that immediately. She would bring that immediately. We're not talking about the time to review. We're talking about the time available to decide whether to accept or refuse, knowing that the consequence of either is that the main housing duty is brought to.
So there is no mechanism within the Act by which the applicant can force a local authority to extend, or can insist that a local authority extend time.
Take the most extreme case. There is a private rented sector offer. You have to accept it within an hour.
Oh, yes.
How do you review that? If you don't accept it within the hour, you're on the street.
My Lord, yes.
So, what is the mechanism for reviewing that decision, that offer?
My Lord, there is not a mechanism for reviewing that offer, but in my submission, it is clearly outside the range of reasonable decisions, and it isn't what happens in practice.
Why couldn't you ask for a review of it under Section 2021B? I mean, it's a decision as to what duty is owed. I mean, if it's being said, this is wholly unreasonable, the circumstances in which you require me to consider whether to accept.
Yes.
Unreasonable to the point that it's unlawful by the local authority. And indeed, that one might think that that is actually ensuring that this does what it's supposed to do, which is give a second look to the local authority to avoid the need for judicial review.
So my Lord, yes, I accept that, and it is also right that the whole panoply of issues that are available to an applicant on judicial review would be available on a Section 204A appeal, 204 appeal, and the 204 appeal is against the review. So if the review came to the decision that we reasonably gave you 1 hour to accept or refuse this accommodation, that would then be susceptible to Section 204 appeal on judicial review grounds.
Yeah,
Right. So just to make sure we've understood your position, in fact, although you're saying to my Lord there wouldn't be a mechanism to challenge, you accept there would be.
There would be, yeah.
All right.
And that's on the footing that the local authority would be saying to the applicant, our duty to you is discharged by an offer of accommodation acceptable within 1 hour.
Yes.
so there's some kind of implied requirement that the offer is not a completely unreasonable one in order for its acceptance or rejection to bring to an end the housing duty. One might put it like that.
My lady, yes.
Yeah.
Yeah, I mean, I think I'd be inclined to say it's the usual public law duty on any public authority not to behave irrationally, unreasonably.
Yes.
And it's just that Section 2021B gives someone a mechanism to say you're behaving irrationally, and
Yes.
that takes you down a particular remedial route.
My lord, yes.
All right.
In relation to Anu Jufreva, that isn't authority for the proposition that you have to be told of your mechanism for challenging the decision, just that you have to be notified of the decision. I just want to go very briefly through the section 20, the offer letter in this case, which is at page 225. So, second substantive paragraph, completion of our inquiries into your application as a homeless applicant. So the local authority has carried out inquiries. Next paragraph, after careful consideration of your circumstances, the council has decided to bring the duty to an end by arranging an offer of an assured short-hold tenancy. So there's the decision. I've taken you to the suitability orders, and in the next part of the letter, we get all of the details that have to be considered in relation to suitability. So we've got the children's education, at pages 226 and 227. Local amenities on page 228. Affordability on page 229, subparagraph 4. Going back to page 226, we have the notification. I must inform you that if you accept or reject this suitable private rented sector offer of accommodation, it will discharge our duty to you. So there's the first notification requirement. B, you have a right to request a review of the suitability of accommodation offered. I must also inform you, even if you accept the offer, you can continue to request a review of our decision. Over the page to page 231. If you wish to request a review, you must put this in writing within 21 days. That's right at the bottom of the page. This is a very far cry from Anu Frucheva, where Mrs. Anu Frucheva was not even told about the decision. Even though she wasn't told about the decision, there is a range of judicial opinion in Anu Jufreva that ranges from Lord Steyn
I mean, interestingly, page 231 at the foot,
Yep.
notification of the right to review. I mean, it's not confined there to suitability.
So that could be regarded as ambiguous because is it referring back to the express right of review in relation to suitability that somebody is told about? I accept it's unclear. But yes, it does indicate an absolute right of review. And you'll see that the date that is provided for the request for review is the date of the date you received the letter. I have largely dealt with the ground 3 position, so I think I can hand over to my learned friend Mr. Mullin to make submissions on behalf of the London Borough of Waltham Forest in relation to ground 2. Thank you very much, Mullin.
Thank you very much. Mr. Mullin.
My lords, my lady, I'm grateful for the opportunity to address you on ground 2. I suspect I'll be relatively brief because there's a degree of overlap between the the arguments that your lordships and lordships already heard. Ground 2 is a challenge to the Court of Appeal's finding that there was a right of review under Section 2021B against a prospective decision contained within the offer letter. The Court's already heard my learned leader's submissions about how we say, actually, prospective decision is a misnomer to some degree. And to posit to just reinforce that slightly and posit an analogy, in our submission, it's akin more to service of a notice to quit, for example, to determine a periodic tenancy. So where a landlord wants to determine a periodic tenancy, it decides to do so and serves a notice to quit. The decision is taken then, and it's a substantive decision. But the notice to quit operates under the common law to terminate the tenancy at some point in the future. And in our submission, that's an apt analogy for describing how the offer letter in these cases work, particularly bearing in mind whether or not an offer is accepted or refused. And in our submission, it must be ultimately one of those two things must happen. That is the final domino to fall. So it is not right to describe it as some sort of speculative or preliminary or decision without legal effect. In our submission, the decision is a substantive one and one which attracted a right to review. We also say that really this is a point that shouldn't be open to the appellant on this appeal, because the learned judge at first instance found that such decisions are reviewable on that basis, and just for the purposes of your lordships, your ladyship's note, page 172, paragraph 30 of the first instance judgment, relying on Ravichandran, the learned judge at first instance found, I quote, both decisions are reviewable. There was no respondent's notice in the Court of Appeal, and indeed...
Both decisions, was that the 11th of June letter and the 7th of October letter?
No, it means the distinction between so at paragraph 30, the manager just says, thus a distinction is drawn between a prospective discharge duty by the I think that should be of duty, by the making of an offer as against the decision by the local authority there has been satisfaction of the conditions of discharge. So the learned judge is drawing a distinction between the offer letter and then some subsequent decision that there's been a refusal and thus the duty is ended. And both decisions, according to the learned judge below, are reviewable. And that's having cited paragraph 32 of Ravichandran in the preceding paragraph. So there was no, as I say, no respondent's notice in the Court of Appeal, and indeed I think it was acknowledged in the case, in the skeleton argument to the Court of Appeal, which is at page 375, paragraph 73A.
So this is the appellant's skeleton, is that
This
right?
is the appellant in this court's skeleton in the Court of Appeal, where they were the respondents. And there is, I think,
Sorry, 73A.
the offer letter of the 11th of June was plainly no more than an expression of a prospective intention.
But
Sorry, no, that's...
just reading that seems to be saying it's not a decision, it's just an expression of a prospective intention. I thought you were showing us that they accepted.
No, I'm sorry. There is where it is stated that he rightly found that there was the right to review both decisions. I'm so sorry. I'll find the reference.
All right.
The next one, I wonder if I've mixed it. Yes, perhaps the best reference, page 365, paragraph 41. And at 41C, said the DCHJ found that the authority must reach a decision about whether conditions were met. And then at C, he considered Ravichandran noted 28, the Court of Appeal had said there was an entitlement to review a decision about the end of the duty. If the review takes place before the refusal, it will strictly be a review of the intention the offer will on refusal result in cessation of the duty. So there was no, and it was not, indeed, the basis of the appellants in this court's approach to the Court of Appeal was that the judge below was entirely right and the decision should be upheld. It's also right, so, and to address the submissions made by my learned friend Mr. Bates KC, as well as the appellants, that there is inevitably, looking at section 1935, there is inevitably a degree of forward-looking, or to use the word I've said we shouldn't use, prospective effect within that route to cessation, because the section 1935C requires that the local authority sends a notice regarding itself that the duty is ended, and the duty can't end under section 1935 until it's done that.
Yeah.
So
that's the nub of the whole thing, that in reality the local authority considers the application that's been made to it and assesses whether the person is indeed eligible for assistance and so forth, and then what resources it has, and decides what offer to make.
Yes.
And when it's doing all that, it's deciding how it is dealing with her case. That is its decision. But the legal consequence of that occurs when the offer is accepted or refused. So the whole issue we've been debating all day simply arises because of the time lag between the actual decision on the case and the legal consequence that follows under section 193.
My Lord, yes, exactly. But the only point I'm making with reference to 1935 is that I think it's said by both the first intervener and the appellant that as a matter of principle, one can't have a decision that looks to some future effect.
No.
And that can't be right because the statutory scheme envisages it.
Exactly. I mean, that's why it's inaccurate to talk about it as an expression of an intention and so
Yes.
forth. They're not talking about what they intend. They're talking about what they have decided, what they are actually doing with this application.
Yes, it's a decision taken before the final domino falls that brings
exactly.
the duty to an end. That it is a decision taken at that penultimate domino stage, and it remains, in our submission, a substantive decision that's susceptible to review under section 2021B. And my learned leader was looking at the offer letter, and indeed the final page of the offer letter with the court before he handed over to me. One other thing to highlight on page 231 is that where the right to review is described, it does say that if you wish to request a review, you must put this within writing within 21 days of the notification of this decision or offer. So it does, to the extent that makes a meaningful difference in my submission. It's right that the offer letter specifically draws attention to the right to request a review of suitability, but then right at the end of the letter it does also include a more general reference to your right to request review. It doesn't specify all of the other species of decision that can be reviewed under section 202, but it is a broader, in my submission, piece of information about your right to request a review. And of course the letter contains both the decision, in real terms the letter contains the decision to bring the duty to an end by making the offer and the offer itself. So that it makes sense that that final page contains those two, that distinction.
The difficulty is that there are lots of reasons why one might rationally or reasonably refuse the offer, which are nothing to do with the suitability of the accommodation, if you are deemed to refuse it because you don't go and look at it on the day that they say. But I think we went round that loop with
Yes.
Mr. Grundy.
I'm not sure there's a huge amount I could add to the discussion that's already been had, but there will be situations where, and I think the appellant rightly accepts, there are situations that are right for the local authority to be able to deem a refusal. The rightness or wrongness, it seems to me, of that will be ultimately challengeable in some way, worst case by judicial review. But there's likely to be some other decision, and I think my learned leader referred to the cancelling of temporary accommodation, which is what happened in this case. The facts of this case are unusual because the COVID pandemic stepped in, which meant that Miss Bano was in her accommodation, her former temporary accommodation, for a very long period of time. And the trigger for all of the judicial review in all of this case was when the private provider of that accommodation brought possession proceedings in the county court, and the duty advisor at the county court looked through the homelessness application and identified that the offer letter made the Norton error way back then, and that's what triggered the whole series of events. But there were, and the court's been taken to Underground 3, the October letter, which is, as the Court of Appeal found very clear, that the local authority considered itself at that stage, so some 4 months after the letter, as not owing any further duty to Miss Bano. And that letter didn't say that it had a right, expressly, that there was a right to review it, but it did contain a decision or notification of a decision.
Of an earlier decision? Or...
Of an earlier, yes. But subject, I'm grateful to my learned leader for covering so much of the ground, but subject to anything he wants me to add or anything I can address your lordships and your lordships on, those are my submissions.
Well, thank you very much indeed, Mr. Mullen.
Nice.
Yes, Ms. Gaines.
Mr. Grundy doesn't want his last 10 minutes.
We're done. Thank you very much.
I'm very grateful. I will be brief. I have some short points, and then I have a slightly longer point, and I will do them as quickly as I can. The first, which Mr. Grundy didn't develop, but he made a point in response to my reply to my Lord Stevens about the change in eligibility decision, the section 1936A, where there's a letter that says the regulations will change in a week's time, therefore you shall cease to be eligible in a week's time, and that I conceded, and I did say she had the right to request a review of that decision. I need to be clear, if the applicant's case was then that there was a supervening event after that letter, but before the effect of the regulations, that she wanted to draw attention to the local authority's attention, or if the local authority knew that there was a supervening event in her circumstances during that week, then I would say they would have to make a decision on that supervening event. And I'm sorry I wasn't clear earlier. That's my first point. My second point is about the wording of a prospective decision, which seems to have crept in following the Deputy High Court judge's characterisation of a prospective discharge. And in that respect, I entirely accept that the right phrase is a decision prospectively to discharge duty. Insofar as still dealing with terminology, there is references to confirmatory decisions. They don't arise in Warsami. The word confirm is in Warsami, but it's only in respect of a review decision confirming an original decision. It isn't about the series of events of we're talking about an offer letter and then a subsequent confirmatory decision. It's only in respect of a review decision. Confirmation does come into Ravichandran, and it gives me a chance to go back to Ravichandran and followed my Lord Sales's invitation about the notion of a confirmatory decision. And what's important to remember about Ravichandran is that the ratio was twofold. One is, as Mr. Grandy explained to you, that a local authority couldn't shift its position from a final offer under subsection 7 and say it's really an offer under subsection 5, and that doesn't concern us. But the other important ratio at page 1439 is that the Court of Appeal, a judgment coming from all of them, firmly rejected the submission by Mr. Andrew Arden, QC as he was, for Lewisham, that the amended section 1937, the difference therefore between that considered on Warsami, now provides for an automatic cessation of the authority's duty. That's clearly put out as referred to as his submission at 1439, paragraph 29. And the Court of Appeal says, in our judgment, Mr. Arden's submission, as well as Mr. Latham's perceived need to address it by arguing for an implied notification provision. So I agree that that's difficult for me, but Mr. Arden's submission are misconceived in the analysis and decision of the Court of Appeal in Warsami. So Ravichandran firmly rejects the idea of automatic cessation, and that was clearly good law until the Court of Appeal's decision in this case. That's the ratio of it. As the respondent rightly identifies, some of the subsequent discussion is about the practical problem for a local authority, because where there is an offer of accommodation, there are two separate rights to request a review. One is the right to request a review of the suitability only under section 2021 F4G or subsequently H, and the other is the right to request a review that a duty once owed is no longer owed under section 2021B. And Ravichandran, having directed itself following Warsami that those two review decisions remained an applicant's right, was concerned with how that would work in practice, and they said very sensibly that there need not be duplication. If matters that had been considered and decided on the suitability review were subsequently raised in a review as to whether the duty had ended, then unless there was new information, those matters need not be considered again. So, and that was a practical solution to avoid duplication. The problem is that they were doing so on a practical basis without a close textual analysis. And when we then do what judges and lawyers do, which is look at the Court of Appeal's decision with a close textual analysis, we end up with the formulations at paragraph 32, page 1440, that there may be a decision prospectively to discharge by the making of the offer. And we also end up by the suggestion of the Court of Appeal that the review of the suitability and reasonable accept requirements, as well as the decision prospectively to discharge by the making of the offer, could have been dealt with at the same time. So that's what the Court of Appeal is putting forward as a solution, but it's not the ratio. And it's not a ratio that says in an offer letter, perhaps described as a decision prospectively to discharge, then the right to request a review of a decision that the duty has ended arises. And in that respect, again, I agree with nearly all the respondent says about the list at paragraph 35 of the principles in Ravichandran, that it's 1 to 5 are the ratio, and when we come to 6, it is right also is the ratio, we would say, that the applicant is entitled to a review of the decision as to the discharge of its duty under section 193 subsection 7 by virtue of section 2021B. Warsami tells us that. But there's then a very confused second sentence in the subparagraph 6, If the review takes place before refusal of the final offer of accommodation, it will strictly be a review of the intention that the offer will, on refusal, result in cessation of the authority's duty. And we say that that is something that just creeps into that judgment. It was overture, it was not argued, the idea that you could have a review of an intention that the offer will result on refusal. The issue in Ravichandran was whether or not there was automatic cessation, and from the applicant's side, whether or not there should be notification. And those are the ratios of Ravichandran. The wording that has crept in was in relation to the Court of Appeal trying to come up with a practical solution to avoid duplication. My learned friend Mr Mullins said that an offer letter was akin to a notice to quit. And we say, no, that can't be right, because a notice to quit isn't contingent upon intervening events. A notice to quit that gives 4 weeks' notice doesn't say, we will require you to leave in 4 weeks' time, because in 2 weeks' time you will do something. Fail to pay your rent or give your keys back or whatever it may be. A notice to quit is the notice that the tenancy will end in 4 weeks' time. There are no intervening events during those 4 weeks, and certainly no intervening events that the applicant or the recipient of the notice to quit would be able to do. It would be under their control. So we say that that analogy is not right. There's been some discussion of whether the letter of the 7th of October 2020 would have been sufficient to discharge the duty. I didn't address those in my submissions. Can I give you that? Thanks. I'm grateful to Mr Marshall Williams for taking my load. But we say that the learned Deputy High Court Judge was absolutely right in his analysis of the letter of the 7th of October 2020. It's page 231. I should say, by the way, that we do acknowledge that an offer letter and a subsequent discharge of duty letter, which is what we contend to, can be some time apart. And if the letter of the 7th of October had been a letter that the duty had been discharged, then we wouldn't be here. If it had been a proper letter, Mrs Bano would have had a right to request a review of that, which she would have had to do within 21 days of the 7th of October 2020, and that would be that. The problem in this case arises, we say, because there is no discharge of duty letter and there should have been. But when we look at the letter of the 7th of October 2020, we say that can't possibly be a discharge of duty letter. It's headed request for review, and it's in response.
So what page number is it?
I'm sorry, page 239. But in fact, to understand it, one has to turn back 3 pages to page 236, which is a letter from solicitors then instructed by Mrs Bano, 28th of September 2020, not my current instructing solicitors. And they write a letter that's headed request for a review and request for a temporary accommodation pending review outcome. And it's clear from the contents of the solicitors' representations that they have been instructed following the cancellation of the temporary accommodation in August. That itself is at page 235. And they make 2 sets of representations. One is that the communications in June amounted to a request for review. And the other, if that's wrong, is that they want to request a review now. And page 239, the 7th of October letter, is a response to those 2 sets of representations. And it very clearly sets out the communications in June, and it comes to a decision that there was no request for a review made, and it considers whether or not it should extend the time for a request for review, and decides that it will not do so because the request was made 109 days after the statutory deadline, which they put as the 11th of June. So it is not a letter, we say, setting out that the offer letter had been sent, it had informed her of the various matters to be informed under the statute, that she had refused the offer, and that the duty had therefore come to an end. And importantly, that she would have a right to, and therefore that this letter, the 7th of October, was a letter deciding that the duty had ended, and that she would have a right to request a review of this letter, the 7th of October, under section 202(1)(b). There is no right to request a review mentioned at all in the 7th of October. It is what it says it is, and what the Deputy High Court judge found it was, which was a response to representations to request for review had already been made, and if not, could one be made out of time.
Which paragraph was the Deputy High Court judge?
The Deputy High Court judge says that at... So sorry. Give me a moment. I'm being prompted. I'm grateful. It is...
Yes, paragraph 6.
My lady's there before me. Yes, it starts at 178. I'm sorry, 179 from section 60, from paragraph 64. He notes the reference to section 1935, which is in the 7th of October. He looks at the context, which is the point I've just made. He looks at the status of the letter's author, a coordinator from the Reviews and Appeals Department. He looks at the heading of the letter, and he looks at, again, at the reference to subsection 5. And at 71, it is clear that Ms Barnes was rejecting the application for temporary accommodation pending review, which was also rejected, rather than ending section 193, subsection 2. So on the facts, we say that is not a discharge of duty letter. If it was, we wouldn't be here. In terms of what is notified... I just failed
to understand the question at page 65. Was this letter, as the defendant submits, a decision that the main duty had ended? Well, there is the duty ends by operation of law. You don't make a decision about it.
Well, that's what's between us. But the respondent's alternative case is that the 7th of October was a discharge of duty letter containing a decision. So and I just needed to respond to that. Can I also make one quick point about the offer letter and what it informs the applicant about her right to request a review. And again, this is something that the Court of Appeal found. The offer letter very clearly, the 11th of June, starts at page 225, very clearly says that she has a right to request a review of the suitability. That's in accordance with section 193(7)(b). That's completely correct. It does not, in terms, inform her that she has a right to request a review that the duty has ended. The most it does is at the end of the letter at page 231, it says if you wish to request a review, you must put this in writing within 21 days of the notification of the decision or offer. 2 points on that. First, that doesn't say, I've just said it, that you could also request a review of our decision, which we say is contained in the letter of the 11th of June, says Waltham Forest, that the duty has ended. It doesn't say that. And we say that if we're wrong on ground 2, and an offer letter can also operate as a discharge of duty decision, then really the offer letter needs to make both rights to request a review very clear, and also needs to be clear about the time running when those 21 days start. And we say that part of the lack of clarity is shown by this letter at the bottom, where it says 21 days of the notification of this decision or offer. Very hard to know what that means.
And you accept that doesn't appear to be a statutory right, but you say it's an anafragia.
It must follow, yes. Yes, I absolutely accept it's not in the statute, but it's very hard to know how you would operate your right to request a review, which is a right, not contingent on permission or anything, and your right to request a review without being told about it, anufrieva, and equally bearing in mind that the time limit starts from notification, section 2023. And since Anu Frieva has been mentioned,
Well, Ms Davis, you're rather beyond your time now.
all right. Can I make one final point? It really is my final point, and it's this. Mr Grundy going through the different subsections 6 and 7 and 7AA was making the point that some of them are triggered by offer letters, some of those events, others are not. They may arise as a complicated matrix of fact and law if it's the case of ceasing to be, the duty ceasing because somebody is no longer eligible. They may arise because somebody has thwarted the purpose by leaving the accommodation, 6B, subsection 6B and D, and they arise through refusal and they arise through acceptance of offers. And in each of those cases, he was having to say under subsection 6, well, there would be a decision. It would be a decision on eligibility, or we might have to make a later decision that as to how we would retrieve our temporary accommodation that had been provided to us. So in each of the cases, there was, in the end, a different mechanism for making those decisions. We say that can't be consistent with the principles of statutory interpretation that would require the same words to have the same meanings. And that what resolves all of those problems about making decisions at different times in different circumstances is what we put forward as a parliamentary intention, that for all of those circumstances, subsequent to an offer letter, if it's a circumstance that involves offers, then there has to be a subsequent decision. And that decision contains the right to request a review, which we know is a right from Warsami, and that resolves all of the issues about at what point subsequent decisions made. Are they just made in relation to retrieving accommodation? And how do you challenge them? Would you end up challenging them through judicial review because a local authority hasn't behaved reasonably when you said I couldn't get to Derby and so forth? There were lots of different avenues being suggested during Mr Grundy's submissions. We say all of those problems are solved by the correct interpretation of Parliament's intention, which is if there is a decision, it is notified to the applicant, she requests a review or she does not, and the duty has ended, and that is the right solution.
Well, thank you, Ms Davis.
For going over.
We're
Quickly, on behalf of myself and Mr Grundy, I would like to make a submission, my Lord. It's a very short point. This is my learned friend Ms Davis's last appearance as a barrister before retirement. On behalf of Mr Grundy and I'd like to thank her on behalf of those who've sat behind her for many years, her opponents for many years. I know from having had a quick look around the room, many of her former leaders have come today. Her clients, as someone who dedicated her life to legal aid, would be very grateful to her indeed. And from both of us and from all those here, we wish her nothing but a happy, long, healthy retirement with as much or as little housing law as she would. I'm very grateful, my Lord.
Thank you, Mr Bates. Well, we're all very pleased to echo those sentiments and wish you a long and happy retirement.
Thank you. I'm grateful and embarrassed at the same time, my lady.
Very well. Well, we're grateful to Ms Davis and everybody else for their assistance. We'll now take time to consider all that we've heard.